Okay, we are back on the record in the Lovelady matter, and we're beginning at 1:30 to dive into the financial issues. So did we want to have a discussion as to exactly what's in dispute, or just dive right into testimony? What would be?
Judge, I think it would be if we had a discussion.
Okay.
Audrey and I spent an hour. Your Honor, it took us exactly 1 hour to resolve this, except we have a few questions, and that's it.
Oh, okay. All right. Well, who would like to start?
Well, Audrey takes better numbers notes than I do, so I'm going to ask Audrey to do that, Your Honor.
Okay.
Judge, so the first thing we need you to weigh in on is whether or not you would apportion Dad's sick time and PTO as having a cash value for the purposes of giving half credit to my client.
And Your Honor, the concern on that was that there was a case about 2 years ago where there was a new ruling by the Supreme Court that, as I recall, that stated that sick time, if there's no cash value to sick time, and that was brought, I think, from the Clark County Marshals. So are you aware of that, Your Honor?
I am not. And I will say, in cases that I've adjudicated previously, not necessarily in this context, but just by way of an example, I had a school teacher that had accumulated some level of leave time that it was simply a matter of me applying. There was an hourly rate that they would apply to those hours, and then I did apportion that to that party as a community asset. So, but if there is authority out there, certainly I'm open to that. I'm just not familiar with it as I sit here right now. But unless there's some type of authority that states that it shouldn't be considered community property, that would typically be the path I would go down, is determine what the value is as of the date of divorce, so when the decree was entered, and then whatever the multiplier is, and typically that's going to be an hourly rate applied against those hours. That would be how I would value that.
And that's exactly what Audrey said has been her experience with you. But Your Honor, I just asked Audrey for leave till Monday to allow me to do the research. I believe that the Supreme Court ruled that there was no cash value, but that's not what you just said, though. The Supreme Court said there's no cash value, not that it wouldn't be divided.
Right. So I don't have a problem with that. But again, because if there is that authority, then obviously I've committed reversible error if they've made that determination. But I'm just not familiar with that. So I'm always up for being educated in that regard. So I know we get decisions that come down, and even if it is unpublished from the Supreme Court, then that still is going to guide my decision in that regard. So I try and keep up as much as possible, certainly on the published decisions. Occasionally I might miss an unpublished decision here or there. But so if it's out there, I don't have a problem. That's going to be the guiding source. But if it's not, that's how I would approach it.
Okay, Judge. Audrey, if you're okay, I'll just give me till Monday, because I'm going to ask you to type this since you've got the best notes. And just give me a couple of days to look at that Supreme Court case. And if I'm wrong, I'll tell you. And if I'm right, I'll show you.
Yes, so I don't have any problem with that. I would go ahead and set forth the value of what Mr. Lovelady owes my client if we don't count that, or what he does if we do, and that way both numbers are on the record.
Okay.
Thank you.
Okay. So, Judge, based on the cash assets that the parties have, Mom has an America First Credit Union checking account ending in 4204 that had a cash value as of December 3rd, 2020 in the amount of 55 cents. She had a savings account as of December 3rd, 2020 with the same last four digits, 4204, with a cash value of $20.07. Dad had a Clark County Credit Union checking account, 2020-79, as of December 3rd. And I might be mixing up the checking and savings, but it all washes out. With a value of $2,781.02 and a savings account ending in 7,900 with a negative value of $5.93. Dad's sick time as of 11/29/2020 was 120 hours times his hourly rate, which is $35.87, comes to a value of $4,304.40.
What was that amount, Ms. Beeson, again? I'm sorry, what?
$4,304.40.
Okay.
He has PTO time of 0.24 as of 11/29/2020 for a value of $8.61. Therefore, the total value of Dad's cash assets was $7,088.10. The total value of Mom's assets was $20.62. If we are offsetting, if we are using the sick time and PTO, Mom is entitled to one half of the difference, which is $3,533.74. If we are not using the sick time and PTO, then Dad owes a cash value of $1,377.26.
Could you state that amount one more time? 1,000?
Sure. $1,377.24.
Okay.
We're in agreement with that, Judge.
Okay.
There are two whole length policies. One is a Northwestern whole length with a cash value of $12,137.25. Dad shall be awarded that policy as his sole and separate property, and we have attributed value to it for Mom's portion that will go through in the community property equalization fee. There is also a Gerber whole life policy held on Abby's life. Dad will maintain that policy as well, and there will be no offset for that. The real property located at 5104 Elk Falls Court. We do know that the mortgage balance as of the end of November 2020 was $218,159.79. The parties have agreed to reach out to the same appraisal company that has done the prior two appraisals to see if they can either do an updated appraisal or comps to determine the value as of December 3rd, 2020. Dad will reach out to the appraisal company by tomorrow. Parties will split the cost to determine the actual value to determine the community property. There is a timeshare that is paid in full. Dad paid off the debt in the approximate amount of $12,000. That is going to be awarded to my client as her sole and separate property. The parties have 4 vehicles. As of 12/3/2020, none of the vehicles had any equity in them. Therefore, the parties will be awarded the vehicle subject to any debt thereon. Jessica is being awarded the 2014 Dodge Ram truck. Mike is being awarded the 2011 Dodge Charger, the 2012 Ford Escape, and then I apologize, there was I think a 1995 Dodge that was premarital property. Not disputing that will also be awarded to him. As far as the parties' retirement accounts, as of December 3rd, 2020, Jessica's MGM Resorts 401k was worth $316.58.
I'm sorry, I missed that amount, kind of went in and out, Ms. Beeson, if you wouldn't mind repeating that.
Sure. $301,716.58.
That was 715 and 58?
No. Would it be helpful if I use the chat function?
I'm catching most of it. Just occasionally the volume fades. So 301,000.
$716.58.
Gotcha. Okay.
Dad's community property share. Well, let me back up. 4 years of that 401k is my client's premarital strip property. However, based on the fact that Dad paid off the timeshare in the amount of $12,000, Mom is waiving any separate property portion she would have for her 401k as a trade-off.
Okay.
Therefore, Dad's 1/2 share of the 401k would be $150,000, $858.29. Dad's 457B with the City of Henderson as of 12/3/2020 is valued at $68,221.87. Mom's share is $34,110.94. We have deducted Mom's share of Dad's 457B from Dad's share of Mom's 401k, leaving a difference of $116,747.35. We have then given dollar for dollar credit to the whole life policy, which only $1,000 would be taxable. 1/2 of that whole life policy is $6,068.62, thereby reducing Dad's portion of Mom's 401k to $110,678.73. What the parties have agreed upon is based on whatever the updated equity in the marital residence is. They will take that amount, determine Mom's half. Mom will reach out to a CPA tomorrow. The CPA will determine how that comports to the pre-tax dollars in Mom's 401k in order to determine what Mom would receive from the house, and then whatever is remaining after the dollar for dollar credit is given will be given to Dad. Everybody caught up with me on that?
Yes.
Okay. So that dollar amount is yet undetermined, but the parties will be working on that and providing that dollar amount. Both of the parties have pensions. My client has a union pension. Dad has a PERS pension. The parties have agreed that the union pension information shall be forwarded to Shan Weinstead at Pecos Law Group in order for Mr. Weinstead to determine if there is a cash value that we can assign to that to again give credit to Dad on Mom's 401k. If that cannot be done, then both pensions will be divided by Gamma Fondi, and we will use Las Vegas Quadro, and the parties will split the cost. As far as personal property, Dad owns a Glock 27 that was premarital. He'll be awarded that. He owns a Glock 17 9mm that is marital property. He'll be awarded that. As far as all other property, each party is going to keep whatever is in their current possession. Neither party has asked for anything additional. Moving on to the debt. Here is also where we might need Your Honor's help. I'm going to go through the actual dollar amounts of the credit cards, and then we'll kind of talk to you about where we're at. We agree that Mom's City Simplicity account ending in 4284 as of December 3rd has a debt of $14,559.28. Mom's City Thank You credit card ending in 9664 as of December 3rd has a debt of $15,472.32. Mom's Discover card ending in 5193 as of December 3rd, 2020 has a debt of $19,930.59 for a total of $49,962.19 in Mom's name. Dad has a MasterCard ending in 9343 with debt as of December 3rd, 2020 in the amounts of $6,425.85. Dad has a Discover card ending in 6776 as of December 3rd, 2020 in the amount of $14,253.23. The total is $20,679.08. Mom has promissory notes totaling $38,740. Dad has a promissory note totaling $5,000. My client is requesting that all of the debt be split equally. Dad is asking that the promissory notes remain each party's responsibility.
Your Honor, I'd like to weigh in on that. That's one of the things that we're talking about. These are attorney's fees. Mom borrowed this money from her parents. We honestly don't know if she's ever going to pay that back. And she used it all for attorney's fees. My client borrowed $5,000 from your mother?
My sister.
His sister, and financed some cars, but he owns the debt, so he owes about $20,000 on debt. Our intention, and what I'm asking the court to do, is to have the parties bear their own attorney's fees costs, and that this debt be their problem, be assigned to each of them and not split.
Well, let me back up, and I want to hear from Ms. Beeson in this regard, because it appears that the discussion is focused mainly on the promissory notes. Is there an understanding with respect to the credit card debts that were just laid out as to how, or is this part of that discussion as well, or is the focus just on those promissory notes?
This is part of the discussion as well.
Okay. And anything you wanted to add, Ms. Beeson?
Mr. Schneider, did you have the exact amount I gave it to you earlier as far as the amount that Mr. Lovelady was able to pass out the community vehicle?
Yeah, that was the 15,726. That's what I borrowed on the cars.
15,726
So
on
if
the
the court,
cars.
yes, if the court recalls, Judge, you did order that Mom should have the same amount to pay her attorney's fees and costs, and that she could take it out of her 401k with consideration of taxes. She didn't want to have to pay for a CPA, so she continued to borrow the money. So she never did take community funds to meet that $15,000 and change.
And Your Honor, my response to that is that my client financed the cars that he's keeping, and that debt he is repaying. We've agreed that the parties would keep their cars and the debt that goes along with them. I know that's not the same thing. It's a little bit apples and oranges, but it's not like he's going to be paying that money back. It's not like he got an advantage. He owes that money. So, and that was attorney's fees. So my position is that she has $38,000, he has $50,000, and by the way, hasn't received my bill in a long time because he just can't pay it. And I'm asking the court to rule that the parties bear their own attorney's fees costs, no matter where the money came from.
Well, let me ask you in that regard. And was it the $15,000 that we're talking about that was essentially secured against the vehicles and used for fees?
Correct.
Is that the amount? So it's around 15,000. That's not perhaps the precise number, but around that figure. And my recollection was that I had authorized the plaintiff to borrow, or to basically take that amount out to equalize the distribution for fees. Independent of that, how much total has been paid in fees on both sides?
You paid me.
Calculated.
Your Honor, do you want from the beginning of the case? Because my client had another attorney.
Yeah, I'd like to know totals on both sides that have been taken.
Okay, Judge, we'll give you a number here. Just bear with me, Your Honor.
That's
Court's
fine.
indulgence.
Not a problem.
Jeez.
That's what I paid so far.
So far,
Not
Mike.
counting any future stuff.
So far, Mike is out of pocket $27,893.69. And how much have you paid me?
500.
Mike's paid me $7,500, Your Honor. That's in this figure. So he paid $20,000 to Ashley Vasquez, apparently, and $7,500 to me.
And around 15,000 came from loans secured by the vehicles. Is that accurate?
Correct. He's keeping those vehicles and he's keeping that debt.
And where did the balance come from? What was the source?
$5,000 from his sister.
Okay. So that leaves about 7,000 just from general community sources. Is that a fair assessment?
Out of pocket, but did you pay that after December?
Yeah, everything, well, there's Michelle Hauser. Housing. Our years might have been. So.
All right, we're not sure how it breaks down timeline-wise, but he's paid, 20 in round numbers, $28,000 in attorney's fees, and again, it's not as though he got an advantage from the community because he's paying that debt back.
All right,
Judge,
Ms.
my
Lisa.
client spent $15,000 with her first attorney. She has paid my office an additional $24,406.50. And without today, she currently owes $4,839. Sorry, $4,740. No,
Okay.
I'm not a math whiz. Hold on. Without today, it's $4,840.
Okay. And the source of those payments?
Jessica, you can correct me if I'm wrong, but I believe all of it has come from your parents. Is that correct?
That's correct.
So that's part of the 38,000 and change reflected in the promissory notes.
Correct.
Okay. And then as far as the other credit card debts, let me just offer this, and then we can perhaps open some additional discussion. As it relates to the credit card debts, and I appreciate the numbers that were offered as it relates to balances, it appears that those are balances right in the neighborhood of the end of November, beginning of December, when there was the stipulation to terminate the marriage by way of a bifurcated decree. Typically what I do when I'm looking at consumer debt like that, and even other debt sometimes falls into that same category, is I'm looking at what were those debts at the time the parties separated. In other words, when the marriage became what you might refer to as irretrievably broken, which doesn't always coincide with a physical separation. Oftentimes it does, and that's what I'm looking at. What was the amount of those debts at that time? Have they been charged up over time during the pendency of these proceedings or since the parties separated? Because to the extent that they have gone up, then I generally find that's a compelling reason to essentially look at the community property portion as the amount that existed at that point in time, that line of demarcation, looking at the separation or when the marriage became irretrievably broken. So that's what I'd be looking at in terms of some of the indebtedness. With respect to the promissory notes, really the way I would approach that is I understand the concept that that the plaintiff or the defendant is going to have to pay back those debts. That's a debt that he's assuming. But it would be no different if it basically had the plaintiff encumbered her retirement plan by removing the $15,000 in change, and that was treated as a loan from her 401k. She would be paying herself back to rebuild that amount. It's a debt she would benefit because the asset still remains in her name. It was just encumbered by using a community property. The fact that she's repaying herself, or the fact that someone is repaying the debt to maintain the asset, really conceptually to me is the same. And so I would still maintain that that amount associated with what the defendant collateralized essentially with the vehicles would be an amount that is due and owing in terms of an offset. Whether that is, and I had previously authorized to have it taken out of the retirement accounts, that amount simply could be reduced or offset from the value of the retirement account as an offset, with each party maintaining responsibility for the amounts owed on their respective promissory notes. So that would be, because that's something I had authorized previously. As it turned out, instead of relying on that retirement account, which had the plaintiff done that, we'd be sitting here with essentially a 401k, or, and I don't know if it's 401k, whatever the title is of the plan. It might be 403b.
It's a 401.
It's a 401k. So
Yes.
we'd be talking about a value that would be presumably $15,000 less, thereabouts, than it is currently, because the money wasn't loaned from the 401k. So I would still treat it that way. I think the simplest way to look at that is use the same amount that we had been talking about when I directed that the plaintiff was entitled to make that adjustment, and offset that from the value of her 401k.
Okay, so Jessica, you'll need to take that dollar amount, that 15,000, and I'll find it, and figure out what the amount you would have had to withdraw from your 401k was, because again, that's the tax dollar. So you can check the CPA about the house and your 401k. That'll be part of the discussion.
Okay.
See, I don't think that's equitable, Judge. She did not take the money. Therefore, there was no tax consequences. So I don't think that she should. So my client, if you want to reduce the 401k by $15,000, I understand the logic on that. But to go ahead and try to add it and say it's after tax, and then now saying plus the tax penalty, that's not right. She didn't borrow that money.
Let me just. I'm trying to pull up the. I'm trying to determine which hearing the hearing that we had those discussions.
Audrey, you had that date. We talked about it.
I did, and then I threw everything on my floor because I thought we were done, so hold on.
Was it October 13th?
That sounds right, Judge.
So the minutes reflect that the plaintiff mom shall be allowed to access funds from her retirement account, plus any tax fees for withdrawing from the retirement account, to pay attorney fees and costs. Defendant dad shall be allowed to access funds from the vehicles in the same amount as mom will receive from the retirement account. Now, I'm trying to recall, though, hadn't it already happened at that point?
It had. My client had borrowed the $15,000, and mom was thinking about borrowing money from her 401k, but did not do that.
So really,
Well,
it appears what we were contemplating is that it would not necessarily be a loan from the retirement account, but it would be a withdrawal, and it would be in an amount equivalent after taking into account what taxes would have been withdrawn. But I think to Mr. Snyder's point, ultimately the retirement account was not I mean, there was no use of the retirement account, and so basically dollar for dollar it would be the same amount. Now I don't, from a tax standpoint, I don't have a problem if that's part of the calculation of the equity in the home. If we want to treat apples and apples the same dollars, I get that, and I get crediting the retirement account by that same amount perhaps is not the same from the plaintiff's standpoint. So rather than offsetting it from the retirement account, I would direct that it be included as part of the analysis of the equalization payment for the buyout of the equity of the home.
So she would be entitled to $15,726 in addition to her half of the equity of the home?
Correct.
Okay.
And then beyond that, each party would be responsible for the amounts owed on the promissory notes. Now, on the credit card debt, I've given you my approach to how I would look at those. I don't know if you have readily available to you information about the amounts of those debts at the time of the separation, and if they're any different, and if so, are they drastically different? Would that change? Ultimately, at that point in time, that's when I would take a snapshot, and I would find compelling reasons to say whatever it was at that point should be divided equally. If there's a discrepancy in the amounts that were owed at that time, do we have a consensus as to when the parties physically separated?
February 7th of 2019, Your Honor.
Okay. And do we know what the debt amounts were at about that time?
I'd have to look that up.
Okay.
I don't understand. Do you, Mr. Schneider?
We have 3 of them, Audrey. We're just going to have to redo the same calculation back at that date.
Okay.
So if you
Then
can
that
obtain
kind
that
of-
information, that's how I would approach that issue. If that
Understood, Your Honor. Audrey and I, like I said, we did it in about literally 45 minutes to an hour. We were able to wrap this up. So,
okay.
Audrey, I'm sure you were comfortable working with me and doing it, just using a different focal date.
And then we're going to have to readdress Ponzo's fees, ad litem's fees, because all of that was after.
Well, right. No, I think that's a separate subject. So we should probably just hit the judge with that now, too.
Yeah. So, Judge, we'll get the figures as of February 7th, 2019 to figure out the credit card debt of the parties.
Okay.
We have the documents. I just don't have them in
That's
my
fair.
hands.
And that's fair. But have I stated enough so that it's understood kind of how I'm approaching that?
I believe I understand it, Your Honor.
You would look at the total amount and divide that by half, correct?
Correct.
Each party would be responsible for 1/2 of the total amount of credit card debt as of that date.
Correct.
Okay.
Right. February 7th of 2019. I got it.
Okay.
Well,
Jessica,
let me ask one
is that
follow-up
correct?
question, however, on that point. Because typically my experience has been that credit card debt generally rises once these proceedings start. Is there any expectation that the debts went down after the separation of the parties?
Debt doubled, sir.
Okay, that's what I would expect, and the reason I generally go down that path is once the relationship has broken at that point in time. From my vantage point, the charges are not necessarily directly beneficial to the marital community. It's possible to get into a very detailed analysis of that, and we could micromanage that and take a look at, okay, was that charge more personal? Did it have any benefit to the marital community? But my general approach is let's use that as a cutoff date. I find it compelling because generally expenditures after that are not necessarily going to the benefit of the marital community. Okay?
Let me backtrack a little bit. So we have agreed that Mr. Lovelady used his best efforts to refinance the marital residence within 6 months. He will provide documentation as each step is completed to Mr. Schneider, who will then forward it to me. Obviously, if at the 6-month mark there is a holdup because of the way that refinances have been going, there will be no issue. He'll be given additional time so long as that documentation has continued to be provided to my client.
Does that clock start running today? 6 months from today?
Yes,
Okay.
which is why we're kind of reaching out to the appraisal, reaching out to the
Understood.
CPA, and trying to get these things done.
Okay.
Audrey, I don't know that it makes a big difference, but because of the way the market's backed up, and Mike already went and looked to see about getting financing, there were 500 credit applications behind. I would ask that the 6-month date start after we have an appraisal figure, because he can't even apply until he knows what we're dealing with. So it might be a week or two, right, Audrey? To get the appraisal.
That's
So it'll be triggered by the date the appraisal comes in.
Thank you, Your Honor.
Okay.
okay. And then, Judge, what we had agreed to, but we're going to have to kind of undo, but so you know where we were coming from, was the parties basically agreed to split all monies paid to Ponzo and to the GAL, and we had kind of figured out what was put on a credit card and what was put up front. We're going to now need to refigure that. But we do agree that after we refigure that, GAL's fees from this moment forward, depending on whether or not there's any credit either way, will be split. All costs for Dr. Hart, who is the family therapist, will be split. My client will continue to pay $188 in child support until further order of the court. There are no child support arrears as of this date. Each party has medical insurance for Abby through their employer. They will continue to pay their premium without asking for reimbursement of half of the premium from the other parent. The parties will continue to share all unreimbursed medical expenses 50-50 pursuant to the 30-30 rule.
And Your Honor, I'm in agreement with all of that. I just would like to see the invoice from Ponzo. It's just an extraordinary amount of money. I've never seen an invoice that high from Ponzo, so we just want to be able to verify it, that's all.
Okay. So that should be disclosed.
So I think she has the receipts today, Mr. Schneider, and then you saw the $1,800 charge on the credit card. So will the receipts suffice for the other payments?
I'm sorry, Audrey, you broke up. Say again?
You have the charge of the $1,800 on the credit card already. Will
Yeah.
the receipt that she brought today suffice?
Do you have an actual, billed receipt from Ponzo? From Nick Ponzo?
She has receipts of payment.
But he didn't do an invoice?
Jessica, did you receive an invoice?
No, I did not.
Well, Mr. Schneider, can you reach out to Mr. Ponzo's office and just confirm that?
Yes, Your Honor.
Okay.
And again, I can still share the receipts that she has,
Right.
and then you can,
Yeah, I don't have a problem with counsel following up with Mr. Ponzo. And,
Again, the whole point is that the parties are going to agree to split those costs for each of the professionals. We just now need to figure out if there's credit or money owed.
okay. So, did I muck things up with going through the debts the way I did?
Now, if you want to give us
No,
another
Your Honor,
break.
you've actually made it better and easier and clearer. Thank you. I mean,
No.
Audrey did a great job, and I enjoy working with
Judge,
her. But
we can done today, and that would be my preference, and I've got
Okay.
Well, but we are done. I mean, all we have to do is some number switching and verification. We're good. Audrey, we'll do it together. You and I just did an amazing job together.
Oh, and I believe the last issue, Judge, is the order to show cause. It was my client's intent to defer that with the hope that we can withdraw it, depending on what happens over the next 6 months. Mr. Schneider's understanding was that you were just going to dismiss that today, so we need clarification on that.
Well, he didn't say he was going. It was my hope that he would dismiss it. I expected that you were going to dismiss that after viewing the audio tape or hearing the audio tape, Your Honor. So I'll submit to the court if you want to hold it open. I understand. If you want to drop that matter, I understand that too.
My inclination is I'm not going to take any further action on the order to show cause today. I do want, let me just be clear about that. I do want to put it in the rearview mirror and look more towards tomorrow and the next day for Abby's sake, and look for good faith efforts on both sides to help Abby through everything she's going through. This is a traumatic experience for the two of you as parties, more so for your daughter, who gets caught in the middle and sometimes gets ensnared in the middle more than she needs to be. And I had that discussion with counsel. The tape that was played was enlightening because I look at both of you as being contributing parts to that. And that's something that just can't happen. Very adult discussions in front of Abby. But I want to put that in the past. I don't, and I think the better the two of you are at moving forward and closing that out and not dwelling on that, the better off Abby's going to be. You know, when I read in the GAL report about legitimate concerns she has about school next year and what that's going to look like, and for many of our students who have had a very challenging emotional year, you throw the fact what our students have gone through this past year on top of the fact that Abby's parents are going through a divorce, you just pile it on this poor young lady. It's been incredibly stressful. She basically missed out on her freshman year. I can feel that from what she's shared with the guardian ad litem, that she's going in as a sophomore and never had a chance really to have that freshman high school experience. That's unfortunate. I think there's some emotional aspects that are very challenging for our students, for our youth. Challenges that I don't think we've seen the full consequences and ramifications of what they've gone through at this point. And so she needs to be showered with that love. And so I although I'm not closing the door, because again, I think, but my focus is on what are you going to do today, tomorrow, and the next day for Abby's sake. So it's not as though I'm throwing it out. I want to be clear about that, but I'm not dwelling on that today because I'm hoping that this is a brighter future for Abby, and let's keep her insulated from mom and dad's disagreements. I'm sure I've told you my feelings about the more Abby can trust that the two of you are not, as much as she knows the two of you don't like each other. That's challenging in and of itself for a child of divorce. If a child believes that mom and dad are actually okay with each other, she's going to be emotionally healthier. Now, I'm not saying you need to be friends or that you're ever going to be friends again, but just keep that in mind for her emotional health and well-being, that she doesn't need to be dragged into adult conversations or conflict. So I'd rather just set that aside for the time being and look towards the future. Okay? All right, anything else?
Your Honor, go ahead, Audrey. Your Honor, I just wanted to point out to the court that Audrey is a very good attorney, and a lesser attorney today would have dragged this case through the mud and drew blood, and I'm grateful.
I appreciate the work everyone has done. This was daunting, and believe me, as we broke because we were having some technical issues regarding the transmission of documents. I spent that time pacing hallways and concerned about what we were going to do, and concerned about the behavior from both of you. And I told your attorneys during that discussion, shame on both of you for having those type of discussions in front of your daughter. And you were both part of it. It did not offer me the glimpse of looking at either parent necessarily in a positive light. That being said, it was a tremendous welcome relief, the fact that there had been some discussion that apparently was a byproduct of that break. And sometimes those things happen. And I appreciate the work of all counsel involved in getting us to this point, because I didn't see this coming. So I truly do appreciate that. Ms. Breeson, did you have a question?
Judge, more of just, I just don't want this to fall by the wayside for another several months. Not that Mr. Schneider and I can't get it resolved, but I would just like a status check on the final order. Mr. Schneider's laughing at me, but he knows if we don't ask for it, we might have the same thing happen that happened last time.
We
No
need
objection.
deadlines. You know what? I think it's wise to have deadlines. I agree. Now we already have the status check that was set. I think it was early November that we have for just to get a check on where things stand with counseling. How much time, Ms. Beeson, would you like to draft these final documents and make these calculations? 30 days?
I would ask for 60
60?
days. Yeah.
I'll submit, Judge.
Just because it's going to take at least, again, 2 weeks for the appraisal.
Fair enough.
Let's do June 28th at 10. Does that work for council?
Yeah.
Yes, Your Honor.
Okay, so that'll be our. Am I looking at the wrong calendar? Hang on.
Okay.
It could be June 29th. Because that's the same, yeah. June 29th is that Monday?
No, that's a Tuesday on my.
Oh, Tuesday, duh, okay.
So do we have?
Yeah.
Is
we
that
do.
slot open on the
Uh-huh.
28th?
How come Monday isn't up here? What? Yeah. Look at ours, Judge.
Oh, that's on.
Yeah.
It goes Tuesday through Saturday.
Yeah.
Yeah, so that Monday is works. Okay. All right. Did you desire to canvass your respective clients regarding these terms and just confirm that we have an agreement that is basically just subject to some recalculations?
I think that's probably wise, Your Honor.
Let me. We've already sworn in the plaintiff. Let me swear in the defendant. Sir, if you'll please raise your right hand to be sworn.
You do solemnly swear that the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
For the purposes of the record, can you please state and spell your first and last name?
My name is Michael Lovelady. First name spelled Michael. Last name is Lovelady.
Thank you.
Okay, and Ms. Beeson, you may proceed first.
Thank you, Judge. Jessica, are you there?
Yes, I'm here.
Okay. Jessica, have you heard the terms as set forth today on the record regarding the division of assets?
Yes, I have.
And do you agree with the dollar amounts that we have set forth on the record today?
Yes, I do.
And do you agree to the division of the same as set forth based on some additional information that we need in the future?
Yes.
Okay. Have you heard the terms as set forth regarding the division of debt put on the record today?
I'm sorry, regarding the division of...
Debt.
Yes.
And you understand that we are going to get the value or the amount of debts as of the date of separation, which is 2019, and divide it as of that date, correct?
Yes.
And you agree to that division, correct?
Correct.
And you've heard the terms as set forth regarding splitting the cost of Mr. Ponzo, the guardian ad litem, and Dr. Hart, which are all in Abby's best interest, and you agree to the same, correct?
Correct.
You've heard the terms today as set forth regarding the child support amount remaining 188 and the medical insurance and the unreimbursed medical insurances. And do you believe those are in Abby's best interest?
I do.
And you agree to the same, correct?
Correct.
You've heard the terms as set forth regarding what we're going to do pertaining to the appraisal of the home, the calculation of the your 401k, and the division of the quadros, correct?
Yes.
And you agree that that is fair and equitable, correct?
Yes.
And you heard that we are going to hire Las Vegas Quadro, and you will split the cost of the preparation of whether it's 1, 2, or 3 quadros for the pensions and the 401k, correct?
Yes.
Have you entered this agreement freely and voluntarily?
I have.
Are you under any duress to enter into this agreement?
No.
Are you under the influence of any substance which would prevent you from entering into this agreement today?
No.
You heard prior to this that we are going to agree to continue joint legal custody with shared physical custody of Abby. That counseling with Dr. Hart shall continue, that both parties will participate in good faith, and that Dr. Hart is not meant to be a witness in this case. You believe that those are agreements based on Abby's best interest, correct?
Correct.
And you agree to the same, correct?
Yes.
And you agree that Abby will not know that there is future court hearings after today, correct?
Correct.
I'll submit, Judge.
All right, Mr. Schneider, do you have any questions for the plaintiff?
No, Your Honor.
Okay. Ms. Beeson, did you desire to also canvass Mr. Lovelady, or do you defer to Mr. Schneider, subject to your cross-examination?
I'll defer to Mr. Schneider so I can respond.
Okay.
I'm gonna, Your Honor, Ms. Beeson was so detailed. I'm going to do an abbreviated version. But Mike, did you hear the terms that were put on the record today regarding the finances?
Yes, I did.
Do you understand all of those dates, times, the pensions, the 401k? Do you understand how that's going to be divided?
Yes, I do.
And you know that focal date's going to be February 7th of 19?
Yes, I do.
Okay. And are you in agreement with those?
Yes.
And most importantly, do you understand that it will continue to be joint legal custody and shared physical custody for Abby?
Yes.
And do you believe that that is in Abby's best interest?
Yes.
And do you also understand that no one, you or no one else that you have control of, is to discuss this case with your daughter Abby?
Yes.
And she's not to know that there's an upcoming court date?
Correct.
Okay, and that you're going to support her and participate in good faith, correct?
Yes.
Okay, and do you have any questions regarding what took place here today?
I do not.
Are you satisfied with the services of your lawyer?
We'll discuss that off the record.
Now he's a comedian, Your Honor. You have to answer the question.
Yes.
Thank you, Mike. Your Honor, unless there's something I missed, I think that covers it.
Ms. Beeson, do you have any questions of the defendant?
Do not.
Okay.
Thank you.
Do both parties waive the necessity of this court making findings of fact and conclusions of law?
Yes, we waive, Your Honor.
Yes, Judge.
And do both parties agree to be bound by these terms immediately pursuant to local rule?
Yes, Your Honor, we stipulate to 7.50. Isn't that it,
Yes.
7.50? Yes.
EDCL 7.50.
All right.
7.50.
Okay.
Yes.
I,
O's a letter, not a number.
I appreciate the discussion we've had and the time spent today. I accept the resolution that's been stated on the record this afternoon, both the stipulated terms and I've been asked to provide my direction and guidance as we've gone through those terms. But for the most part, they were stipulated terms with some input and direction provided by me. I accept those terms as fair and equitable as it relates to the financial issues. I accept the terms regarding the child, Abby, both that were placed on the record earlier today and this afternoon as being in her best interest, including the aspects of child support, health insurance, unreimbursed medical expenses, prospective participation in counseling, and significantly insulating and keeping Abby from being involved or knowing about these proceedings at any point. So those orders should be reduced to writing. I've already pronounced the parties divorced, so there's no need to revisit that at this point in time. An absolute decree of divorce has already been granted and signed by the court. So this simply should be submitted by way of an order based on these proceedings. Any volunteers to draft from today?
Your Honor, I would ask if Ms. Beeson wouldn't mind doing it and my signing off. It's fairly complicated, and she did a great job with detailed notes on the finances.
All right. Ms. Beeson, you okay with that?
Mr. Schneider willing to pay half my attorney's fees?
I offered to buy you lunch.
I don't think that's enough.
All right, lunch and dinner.
I'll prepare.
All right, I appreciate that, Ms. Beeson. All right, so we have a status check set for the submission of that documentation. And to the
Yes, Judge.
extent there are issues that arise from those additional supplemental calculations that, in part, in significant part, I've tasked counsel to perform. So we have that date set as well as the status check on counseling. So, all right, well, I'll await receipt of that order. If it is submitted in advance of that hearing, I can vacate that date and we'll just keep the status check on. Okay? I appreciate your appearances and the hard work that was undertaken to reach this resolution. I'll await receipt of the final paperwork.
Your Honor, I just want to thank you very much.
Thank everyone for participating. Have a good day
You're an
and
amazing
a great
judge.
weekend.
Thank you.
Your Honor.
Thank you, Your Honor.
I may throw in Mr. Schneider's comment in the order, though, that I'm wonderful.
You can put it in there. I'll sign it.
All right.
Thank you.
Appreciate it. Thank you. Take care.
Take care, Your Honor. Thank you.